why the Data Protection Act is important, why it is supposed to flow from our right to privacy, and what was called the Puttaswamy judgment. The Puttaswamy judgment, as you know, accepted or established that we all have a right to privacy, and therefore the Data Privacy Act really flows from the issue that we have a right to privacy. It's a fundamental right and it needs protection because, after all, the data we are generating today, and it's a huge amount of data that we generate, is in a domain, a digital domain, which is, of course, largely technologically driven, which most people do not understand, and therefore the need for an authority which understands the domain and can prescribe the rules of how they should be governed. So, this is the genesis of the Act itself. I will just digress for a minute here to say the Puttaswamy judgment did also something else, which it used the opportunity of the data privacy issue that it was handling as a, of course, not data privacy, but privacy as a fundamental right. It also struck down the ADM Jabbalpur judgment, which was which was during the time of emergency, which had said under conditions of emergency we have the fundamental rights, but that we cannot exercise them. So effectively, it says that you have the right, but the state can do whatever it wants, and there is no legal redress. So it was a 9-member bench that the Puttaswamy judgment had. 6 members used that opportunity to strike down the infamous ADM Jabbalpur judgment, and I was one of the also uh, people who had gone to the Supreme Court on this issue because I was at that time it was emergency and I was in jail at that time as well under the Maintenance of Internal Security Act. So I have a connection to the Puttaswamy judgment in a different way, which I would like to just reminisce about, just talk about for a minute. Coming back to the Act itself, you see, the right to privacy, of course, did not need a separate act. It did not by itself need the paraphernalia that we are building up today, except for the fact that we today spend an enormous amount of time creating data on the internet and consuming data on the internet. Therefore, we have created a technological environment within which data is created, it can be accessed, it can be used. And therefore, the need for an act to clothe the right to privacy that we have in the digital domain is what led to the Data Privacy Act. The problem with this is that what do you do vis-a-vis big companies, what are called data fiduciaries here, Google, Facebook, etc., etc. The government itself, which in India probably collects even more data than the big data monopolies. And of course, how do we see that this is not misused by the authority, by the company collecting the data, that it is used for the purpose we have given the data, and also that it is not misused by the government. So therefore, the Data Privacy Act should protect us both from the big data monopolies and also from the government in protection of our fundamental right to privacy and various other things that flow from it. Let's face it, the monitoring of people has obviously various elements to it. And of course, it is not only the question of privacy, but it is also the question of life and liberty, particularly liberty, because as we know that there are various now acts of the government, and when I mean by act, I mean legal acts. You have the PMLA, you have the UAPA. In fact, anything that has the word prevention to it in the act, like the Prevention of Money Laundering Act, the UAPA, the P is also prevention. The minute that I see the word, the P, I know the protection is for the government, it is not for our protection. Therefore, the protection is the really the issue that is a flag. What does the government, what can the government do vis-a-vis what we are doing? And there, the question is, do we have protection against what the government is doing? Can we assert our fundamental rights in that regard? And of course, as you know, both PMLA and UAPA have virtually ruled, and this was the Khanvilkar judgment of the Supreme Court, which says basically jail is the rule and bail is the exception. So, which means that effectively we have to prove our innocence before the court, at least the presumption of innocence, in order to get even bail. And as you know, the judicial processes in this country can go on for years. And for people like me, at the age I am, the unlikelihood of such thing being concluded in time, and we have the case in which person was released and he died after, I think, 2 months of his release. So these are the concrete issues why these things which may appear to be nitpicking are important for us. Coming back to the framework of the Data Privacy Act and the rules, the issue is that the board which Anwar talked about, the board is essentially an instrument that is being created to regulate, if you will, the data fiduciaries. Vis-a-vis the state, it doesn't seem to have any role except as a pass-through. Whatever the state asks, it will do virtually. So those rules are almost, when it comes to the rules vis-a-vis the government, they're completely permissive. It allows virtually government to do anything it wants. If you take, for example, the telecom domain, where the government has the right today to tap phones. How many agencies can do this? There are already officially 10 agencies that can do this. And what is the permission to be given? Permission is given by a government official. If you take the number of cases he handles, obviously he himself doesn't handle the permissions, though it is supposed to be a certain rank and so on. It's essentially a permission which is given mechanically. So 10 agencies, mechanically, anything they ask for is given. So what we have got in this circumstances for the Data Privacy Act also, a board which is going to be set up by the government, and the rules that are that have been prescribed give virtually a complete free pass to the government to do what it wants. And therefore, the protection vis-a-vis the government is extremely limited, if not non-existent. So this is one of the problems. Though it's a fundamental right vis-a-vis the government, we cannot exercise this fundamental right because of the rules which have been made, which are so permissive. So we are back to the ADM Jabbalpur case, where we had the fundamental right to life and liberty, but we could not exercise it. That was the essentially the ADM Jabbalpur decision of the Supreme Court. So here we have a right to data privacy. We have the right to privacy, but vis-a-vis the government, we cannot seem to be able to exercise it. This is how the rules have been framed. The second part of it is that this data protection board is not a regulatory board. It is really an adjudicatory board, which means that if our right is violated, we can go and appeal to it to do something. But in terms of what it means for us, it means for us that this is not going to help in setting in policy guidelines expanding the scope of privacy, looking at all these issues in a regulatory right, but it is going to be only what the government does. It's a filter to say yes or no. And the way it has been set up, it is essentially whatever the government says is likely to be yes. So this is one part of the picture. Other is vis-a-vis data monopolies. And here, the original Data Prevention Act had or had actually quite a number of provisions which put on the fiduciaries a certain set of responsibilities, effectively with respect to data localization. Of course, data localization is a two-way sword. It cuts both ways. Because it is here, data, the government has right to access whatever it wants. If it is in US, then of course the US government is involved, and generally the government of India's claim is they're not responsive to Indian agencies. So by that argument, if we are with data fiduciaries and with digital monopolies operating under US law, are we better off? Of course, vis-a-vis the US, we are not, because the US government is also equally permissive, though they officially are not, regarding what they give or do not give to the US agencies. But vis-a-vis Indian agencies, would we get a little more protection is a different question. But data fiduciaries were supposed to localize the data, which means they would have also come under Indian law. It appears that as Trump has now also emerged on the US scene, that Indian government was already making overtures that we are not going to interfere with your digital monopolies, unlike what the European Union has done, and we will allow them whatever they want with our data. So these are some of the issues I think we'll have to check. Of course, the question I have not raised is the question of encryption. The provisions under the rules are such that it might mean that the data companies operating in India will need to break the end-to-end encryption if the government asks of it. So this is still something which I guess at some point of time might be tested in court, but that is the preliminary reading of it. My only last comment would be that we have, as citizens, our protection in terms of data vis-a-vis the government seems to be extremely weak as far as the rules are concerned. And whatever the Puttuswamy judgment gave, the act closed, and what finally we are getting through the rules is virtually very little protection. And I'll stop with that.